we passed the final approach fix, and we're on week 9 of our discussions and lessons. The final approach is coming up very quickly. This week we're going to be studying labor and employment law generally. How will that affect you? Well, if you're an employee of the government, you're an employee of an airline, you're an employee of a charter service, you're an employee of a ag service company, any flying that you do where you are an employee, you're subject to the labor and employment law, and you are also protected by it as an employee. You also can be protected by it as an employer, provided you have followed all the rules that are set forth. Labor and employment law is a growth industry for plaintiffs' lawyers. There's always an area of active contention in the airline and aerospace industries. It just is there. These industries have long histories of discrimination and worker dissatisfaction. These continue to prompt litigation and union organizing and collective bargaining activity. In order to keep the employees properly compensated, keep them safe, give them the benefits to which they are entitled as a part of their employment. That's what this chapter will discuss. The purpose is to familiarize you with the basic principles of labor employment law and to enable you to avoid the common legal pitfalls that trap unwary managers and union representatives alike. If any of you keep abreast of national news, you can see how now all these various assertions are being brought forth by people who believe they were discriminated against in their employment in one way or another, or that they were abused during their employment. All of those matters arise under labor and employment law. Some of them come into civil rights law as well. But it's very important to know that there is a crossover between your civil rights and what may be provided for you under labor and employment law. Congress is considering a bill now that would afford workers greater protection from employers' coercion for engaging in union organizing efforts. Professors, we follow the course of this litigation, named the Employee Free Choice Act, and it has come up that now in California and in some other states where the federal courts have agreed that you don't have to pay the dues if you're not a member of the union. In many cases, whether you wish to be a member of the union or not, you are required to pay union dues to cover it. Government jobs were primarily in that situation where there was a bargaining unit, and whether you wish to be an active member or not, you paid the dues. Well, there have been some cases that have come before the courts that are amending that to make it not necessarily proper for the dues to be collected if the parties are not members of a union and do not wish to be. That's why it's called the Free Choice Act. There was a closed shop situation where in order to be employed, you must be a member. You will come, as pilots, you will become very much aware of the Airline Pilots Association, the International Airline Pilots Association, various other associations, which are in essence unions, that kind of set the rules for how you will be treated by the employers. Many times those unions and the dues that you pay are a good investment. Sometimes they feel oppressive. Sometimes it's very difficult when you're barely making ends meet as a right-seater just getting started and barely making enough to keep body and soul together, be required to pay union dues. But as you progress in your careers and you become more and more valuable to your employer, the payment of union dues is less and less a burden. But there are other things that could be discussed about termination. What right do you have to employment? In California, it's an at-will state, meaning you can be dismissed at any time. Read through the materials. go through the workbook and be ready for an understanding quiz.